Hello everyone, today I will be presenting to you my case brief presentation. Citations: R versus Uvaraja, 2013 SCC 41. This case was broken up into three issues, the first one being the ASF, the agreed statement of facts signed by DS, the minor, then the cross-examination of the same minor by the Crown, but they were not able to due to solicitor-client privilege, and then both of these issues were brought to the Supreme Court of Canada. The facts of this case: Yusantan Yuvaraja, the appellant, helped plan a murder after a busted drug deal. How he did this was provide a weapon, plan the time and location for DS, a minor. DS's full name is not used throughout this presentation because we are not allowed due to the fact that he's a minor. They both pleaded for second-degree murder, but in fact were charged with first. The laws in this case are first and second-degree murder. First-degree murder is when it is planned and deliberate, meaning it is committed pursuant to an arrangement under which money or anything of value passes, or most importantly in this presentation, is intended to pass from one person to the other. And then also if it is someone counseling another person to do any act causing or assisting in that death. Second degree murder is said to be in the law that anything that is not first degree. A few more important facts about DS. He was charged in youth court as opposed to the appellant. But also he pleaded for second degree murder and was sentenced as a youth. In this plea agreement, DS was to sign an ASF. As I said earlier, an ASF is an agreed statement of facts. In this agreed statement of facts, the Crown had said that DS had been given the gun by the appellant. Then he ordered DS to do the shooting and demanded the return of the gun. During trial, DS played dumb and said he did not remember signing the ASF. He then testified that the gun was his. He then shot the victim for his own reasons and had thrown the gun in the river. Due to the negligence of DS in question of the ASF, the court then granted the appellant's appeal, which was that the ASF was not as admissible in court. The judge then called for a new trial and that the ASF was not admissible evidence. The issue in this part of the case is, did the trial judge err in finding that the circumstances surrounding the making of the prior inconsistent statement did not provide sufficient guarantees of substantive reliability? Here we are obviously talking about the ASF signed by DS. These are the appellant's views on the ruling by the judge having to do with the ASF. Obviously he was very positive about the decision that the ASF would not be admissible. With the ASF, the Crown could win the case and put away the appellant for up to 25 years without parole. And even then, if he had parole, it would be a fake of hope. Parole is him being able to speak on the fact that he wants to get out. It is unknown if the appellant is the one who indicated DS to deny having signed the ASF during his testimony. And these would be the Crown's views on the ruling of the judge. The Crown was very upset by this because they were there when DS had signed the document, but no, they had not had a recording or a videotaping of DS signing the document. This document could have been an easy way for the Crown. After the ruling for the ASF had passed, a new issue was brought up to this case. This issue was whether or not the Crown Counsel would be able to cross-examine DS. The Ontario court ruled that they would not be able to because of solicitor-client privilege. More facts about the new issue are that DS was not filmed while signing the ASF, and neither was he put under oath about it because apparently that's unethical. And then if the Crown had taken a recording of the signing, that would have waived all solicitor-client privilege. After listening to all these facts, the Ontario court ruled that they would not allow the cross-examination. The issue for this section of the case was Did the trial judge err in finding that the cross-examination did not provide a sufficient basis for the jury to assess the truthfulness of the prior inconsistent statement? After both these rulings, these issues for the case were brought to the Supreme Court of Canada. At the Supreme Court of Canada, trials were held for both of the issues from the previous trial at the Ontario court. The Supreme Court of Canada ruled that the whole case should be restarted from the ground up and that all evidence, including the ASF, would be destroyed and had to be resubmitted. The rationale of the judge at the Supreme Court of Canada was that the Ontario court did not do their job well enough to analyze the ASF and the cross-examination possibilities. The reason why they had to order a new case was because they would need to do a better job. Throughout the whole trial, the Ontario court did not do a well enough job to have grounds to continue the trial. The judge states that, based on my analysis above, I do not think that a proper analysis was conducted in this case, particularly in relation to the opportunity for cross-examination and the consideration of other potential indicia of reliability. Accordingly, the decision of the Ontario Court of Appeal should be upheld and a new trial ordered. Reliability may be properly assessed at the new trial and the evidence may be appropriately admitted or excluded upon consideration of all the relevant factors. The judge also states in his rationale that he thinks in particular that the decision for the cross-examination not being permitted was off because of the 6 points that would have allowed for questioning. One being DS's understanding of the ASF, two, DS's understanding of any conditions that were attached to the plea deal, and three, DS's understanding of the consequences of misleading the police. Continuing the 6 points brought up by the judge for the cross-examination. Number 4, DS's motive for making what he now asserts were false statements. DS's instruction to counsel regarding communications to the court and the Crown. And number 6, DS's knowledge to the Crown's theory at the time he provided counsel with instructions. This is my analysis of the decisions made by the Supreme Court of Canada and the Ontario Court. First off, I think that DS got off the hook with his signing of the ASF. That ASF could have really hurt him and the appellant. I also think that he and the appellant were very lucky that the Ontario Court of Appeal didn't have a good analysis and didn't bring up the 6 points that the Supreme Court of Canada judge had said. Which my survey question that